Good evening. My name is Joe Sam Robinson. It's our pleasure to have with us tonight Dr. Buck Melton. Welcome, Buck.
Greetings.
You know, I think this country is crying out for your skills and talents in Washington, and the next electoral cycle is soon upon us. I'll just throw that softball in your direction and see if you plan to hit it back to our audience tonight.
Well, I'll just certainly take that under advisement.
Okay,
So
thank you. I think that was
you'll
wise.
be the first to know. I will announce it here.
Right, okay, that's good. So. Now, pursuant to your skills and talents, I know you're a student of the Supreme Court and follow it closely. Do you have any comments about the recent leaked memo in regards to the apparent overturning of Roe versus
Wade?
Wade?
Yes, and
Yes.
Planned Parenthood versus Casey as well.
It's 1992.
Correct.
Right,
Very
that's
good.
correct.
Very
And
good.
I got that one. And the other one was, I'm not sure of the year, 73 or so.
73, very good.
Good. All right, well, so in any event, can you comment on this? What's going on? I've heard many people say that on both sides of the question, that the way the logic and reasoning behind the initial opinions are a stretch. Comments?
I've read and I think everybody has comments to make on what has happened. I've read the opinion. I don't think it is a stretch. The pro-life side of this debate and the Federalist Society judges, that society of fairly conservative judges, this opinion, such as it is, and this may certainly not be the final opinion. It was a draft opinion.
Oh, I'm thinking about the initial opinion.
Oh, the initial opinion. Oh,
right,
yes.
The logic behind that.
Oh, yeah.
Pulling the right out of air, kind of speak.
Well, my answer to that is what logic? And once again, that is sort of a conservative talking point.
Yes.
But it really is true. That was an extreme example of judicial activism. And if you're approaching this from a perspective of judicial philosophy or legal philosophy or constitutional interpretation, even if you are pro-choice, I think if you're being intellectually honest, you find the reasoning that the court used in Roe versus Wade a shambles. And that shambles was somewhat rectified in the Planned Parenthood v. Casey decision. It took away the most egregious parts of Roe versus Wade while leaving the right to abortion still in the law. But I think one of the things that has damaged the court so badly, not just in the area of abortion law, but just in general terms, is how bad a job the court did in Roe versus Wade. So in a lot of ways, the court has opened itself up to this. And I think, once again, if you're being honest, you have to say that whether or not you are pro-life or pro-choice.
Well, I think the comment is made that it's precedent. And so if the precedent is there, even if it is on a wrong intellectual foundation, it's there. And it's not changeable.
Well, Plessy versus Ferguson was a precedent as well, and I think no sane person except, let's not qualify it. No sane person would argue that should have been left undisturbed.
Well, just to proceed with that, does that mean that it's appropriate for the court to episodically just do things out of the air? Just these are the circumstances we have. We have precedent. But we're going to, as well wishes for the country and society, we're just going to have to use our imperium to reverse the situation, since the political system doesn't seem to come up with an appropriate answer. And as wise men and women, if we look into the future, unless these issues are corrected, then something terrible will happen. Is that something that should be on the mind of the Supreme Court? Do they have the privilege of acting illogically when necessary?
Well, it would take me probably an hour to unpack those one or two sentences you just said.
Yes.
The phrase raw judicial power, which the court is fond of using, usually dissenters use
Yes.
it when they don't like what the court has done, comes to mind here. This is what courts have always done.
Yes.
If you take the interstate commerce power as an example, which is something that's a little bit less
Yes.
emotionally fraught, and if you look at the history, in the beginning period with Chief Justice John Marshall, they had
Yes.
an expansive version of Congress's interstate commerce power. Then in the late age of laissez-faire, conservative social Darwinism, they constricted that power a lot. Then when the New Deal came along, they greatly expanded it. This is just what happens. And now, once again, it depends on the justice you ask. In my view of judging, which should be essentially judicial restraint, that judges shouldn't be looking mainly at policy issues. They should not mainly be looking at what effect this opinion or decision will have going forward. Judges should be focusing in on the narrow question, the issue between these two parties. Now, I might relax that some for the Supreme Court when you are dealing with big foundational issues, such as constitutional matters, but I think that's still the approach that one should take. I do think if you're going to look at it from a perspective of policy, what's good for the country, you've got problems both with Planned Parenthood versus Casey and this Dobbs decision that's coming down the road. One of the things that the court did in Planned Parenthood was to try to say, we want this to be the last word. We are establishing this as a super precedent, and we are not going to look kindly on people continuing to challenge a woman's right to an abortion. Well, that was just asking for trouble, because decisions go away, decisions get modified, decisions get overturned. And this court, if in fact the court does strike down Roe versus Wade, this is not going to put this issue to bed. This is going to cause a massive, it already currently is, and it's not even official yet, it's caused a massive firestorm. It's thrown gasoline on the culture wars, and I cannot see the end of it. So anytime the justices say, well, this is the last word and
Yes.
we will settle, they don't know what they're talking about.
It seems to me that we've raw judicial power that doesn't seem to comport with American democracy in many ways. And we've had in our history, we've had the idea, in some ways, the revolution unhinged the traditional arrangements of the British judges. And it was not long, I think, in the Jacksonian Revolution that the people started to vote for judges, and in fact, they still do in Georgia. There are votes
there. They do
there,
indeed.
but it's kind of a faux vote in that the fix is in. It would be very unusual to have two judges or two struggle mightily against each other. It's very restrained, which is an interesting issue, isn't it?
Yes.
So if you look at the way the judicial system works, and you have the appointed for life, with you're certainly insulated a lot from democratic arrangements, and in general, I think often judges would be reflective of the community views, or there wouldn't be, if I can phrase it this way, really highfalutin Olympian figure that would not do too well in the political arena. I guess it's possible. But
I sincerely doubt it.
But so the judges that wind up there are a very elite group of men and women of great intelligence and presumably
Presumably great
although,
intelligence. So.
Presumably, but not necessarily. But so the people are crying out, we want our opinions heard, but they're not suggesting elections. Or, in the other point about this is, in the court is adopting such philosophical, I guess, opinions, or they're far often past law. They're really into sociology, they're into geopolitics, they're into all kinds of things. not having lawyers on the Supreme Court. I mean, is that an appropriate thing? I don't know. Or is it an appropriate thing to say we're going to have quote, a balanced court? That means that we're going to have an Afro-American woman in there. On the other hand, do we have a Southern Baptist on there? I mean, I don't know. I don't think we do.
I don't believe we do.
But you
I'm
could
not
say,
sure.
or maybe we do we have a person of Asian descent, or do we have a person of different different kinds of.
Forgive me. This is the first time this has ever happened on this
Well, I hope it
show.
was that
I
a
told
wife,
my
Graham?
no. It was an automatic call, and it may still be on. And I told my watch to send it to voicemail, and instead it started blaring at me.
Well, there you go. So it wasn't taking orders. Well,
Yes.
getting back to the issue of the Supreme Court, so philosophical issues that are there, and the justice. It does appear that the way that things have happened in the way the Supreme Court has been formed, it's a very contentious arrangement. The way we're putting people in, who gets on there, and it really becomes sort of political appointees that are responding to different political pressures.
Yes. Well, I think you've raised two separate issues here, and they're kind of merging. One is the idea of different constituencies, and as a Southern Baptist going to look at the law differently from, in the words of Sonia Sotomayor, Associate Justice Sotomayor, a wise Latina woman. And the answer is obviously yes. The idea coming out of the positivist school of the late 1800s was the law is the law, and anybody who is thinking in a reasonable way is going to come to the same solution.
Yes.
And obviously not. So the idea for different constituencies, perhaps, but also you got a Constitution. It's a 4-page document, not counting the Bill of Rights. Throw in a couple of extra pages for that.
Yes.
Now they're 4 big pages.
Right.
But the Constitution does not purport to try to answer every question. And so the federal courts are going to have to fill in the gaps. They're going to have to interpret. So the question is, at what point, if there is a point, does a legitimate judicial style interpretation stop and a more overtly political policy making function begin? And that is what you see a big fight over. But the constitutional principles, as Chief Justice Marshall once said, we must never forget that it is a constitution we are expounding. This is not some here today, gone tomorrow law. That the justices are not just representing the current electorate. They are representing past generations. They are representing unborn generations. And so the electorate is going to be different. And so obviously the registered voters who are here right now reacting to this particular opinion, whatever it is, yes, they get a vote, but theirs is not the only vote. They have a lock on Congress, they have a lock on the presidency, and they have a lock on state governments, but they don't have a lock on the federal courts.
Well, maybe we can segue at this point into the decision that is shaken the foundations of the Republic, or Justice Alito's opinion. And I think, did you mention you'd read it, or
yes,
you have?
I have.
And what are your comments about that?
Well, I think that it is, just in terms of the reasoning, I think it is better reasoned than Roe. Now, that does not necessarily mean it is any less politically motivated than Roe. I think it stands up to philosophical, judicial, logical scrutiny better. But obviously, the majority, if they sign on to this opinion, and maybe we better digress here for a minute, that what has probably happened is a vote was taken, and in the majority, if there was a 5-4 majority, either the Chief Justice, if he's in that majority, or the senior associate, which would almost certainly in this case be Clarence Thomas, would assign the opinion to be written. So they've taken a vote on the outcome, but the opinion hasn't been written yet. Well, Alito was apparently assigned the opinion. He wrote the opinion. He now circulates the opinion. And depending on what he says in that opinion, he may gain or lose votes, which could shift the outcome of the case. So, but I think it's a fairly solid opinion. He points out all of the massive problems in the Roe opinion. He points out that there is absolutely zero precedent or historical tradition for the idea in American law that the right to abortion was integral to the law, and because of that, it doesn't get the kind of substantive due process protection that other unwritten rights should get. And that being the case, Roe and its progeny are all wrong. They never should have been decided, and so we're throwing them out. There's nothing really controversial in that kind of reasoning. Now, in the outcome, of course, it's tremendously controversial. It's probably, other than slavery itself, the only thing that could drive this country to open civil war, and we may be sliding in that direction right now.
Now, one of the issues, I'm no expert on this, but in the opinion, or in Alito's opinion, apparently he specifically excluded, homosexual rights, if you could say that, and which these are another set of personal rights that the court just cut out of whole cloth. There's absolutely nothing in the Constitution about that. There are many years of, if you want to use the word precedent or laws or whole tradition of saying, well, you have no right to this. And apparently Judge Alito specifically excluded, any change in that set of circumstances. But logically, I mean, if the court has said the reasoning here is inappropriate, and people opposing this change are saying, well, the next step is to, I think there was no expert on this, but some decision that took place in the last decade or two. The Supreme Court said, well, homosexuality is a right that's in the Constitution. Yes. And if you impinge on that, then you're violating whatever amendment it is that they fashioned this privilege. Well, that's really, I mean, those things together have tremendous cultural impact. What about is it logical if you outlaw abortion that you, or you just remove the protection it has? Would it be logical for the Supreme Court to remove homosexual protection and just say the same thing? Well, it's the states can have that. It's not our job to do that. Yes. Do you have comments on that?
Well, you are certainly hearing from the left and from the pro-choice side that this is the beginning of a slippery slope, and then you get this parade of horribles that next they're coming for birth control, which is also not found in the written Constitution, same-sex marriages, and these sorts of things. All of these stem from largely the Griswold case, Griswold versus Connecticut, 1965, in which the Supreme Court discerned this unwritten right of privacy. And so the left is arguing exactly what you have. If all of these things are based on the right of privacy, then what's next? And to be fair, there are several very right-wing politicians throughout the country, including at least one or two governors, who are saying, well, we're now going to start looking at certain types of birth control next that function as abortifacients. That's the next step. So could the court, once again as an exercise of raw judicial power, scrap Griswold versus Connecticut? Yes, it could. Is there a likelihood of that happening? No, I don't think there is. Alito said, look, let's look at all of these other rights. Yes, they come from the right of privacy too, but there are a couple of big differences. Difference number one, Roe versus Wade never even bothered to tell us what it was basing a woman's right to an abortion on. Was it the right of privacy? Was it the 14th Amendment due process clause? Was it the 9th Amendment? The Roe court didn't even say. So it's distinguishable right there. Secondly, you've got something in an abortion case that you do not have in any of those other cases, even if you assume for the sake of argument that abortion is coming out of the same wellspring. And that is that you have fetal rights. You have the rights of and I wouldn't quite say third person, because I don't think Alito used that language. But once you bring in another entity with at least potential rights, then you have something that you don't have in any other cases. Now, is that arguable? I suppose there's some brilliant lawyers who could say that's nonsense. But if that's where the court's coming from, that's what matters. And I frankly think that it's a very defensible dividing line. So, and a final point, and this doesn't really have anything to do with the opinion. Yes, you've got the right who is pushing really hard for this, but regulating birth control and rolling back same-sex marriage. But I don't see a genuine possibility for a groundswell in that direction. I just don't see federal judges who would be willing to go down that road. Now, 50 years from now, who knows? But I think that is a bit of an hysterical response at this point. I may be wrong.
Just to continue on the subject, I think occasionally, once again, somewhat out of my purview, but some person might be quite pregnant, maybe in the last trimester in a car accident or something. Someone hits them, and there's litigation that takes place, and money is exchanged. And presumably, I think that the unborn infant in the mother's womb, some kind of recompense takes place for that. We're going to award some money because of the unborn child, or at least efforts to do that. So would there be a stricter protection of, let's say, someone in the last trimester? And getting into the idea that this could be infanticide or a murder, if you actually did a late-term abortion, and could this be a murder charge?
It's certainly possible, and that has, in fact, even during the Roe era, which frankly may not have come to an end yet, this is only a draft opinion, but it has been litigated. And I know in state courts, and this would be based on state law, it would perhaps be based on how state laws are written, because I don't read the Dobbs opinion, if it's a real opinion, as actually granting rights of personhood to the fetus. So that would be a matter of state law. So California, for instance, there was the murder of a pregnant woman, and I believe the state brought a double homicide case. Yes. And the California courts ruled, based on their interpretation of longstanding California law, that would not fly. But it would depend on exactly how the laws were written in the individual state, how the law might end up getting rewritten as a result of the Dobbs decision, and it would also depend on which judges got elected or appointed or what they had for breakfast, if you want to get down to politics.
One other comment on this, I think the idea of, I guess, abortion in earlier times when families were a lot tighter, if you could say that. And it'd be very unusual to have an illegitimate child, and a lot of shame attached to it, and et cetera. Now it would appear that an enormous number of American citizens are born out of wedlock, so to speak. And what I'm getting into is I wonder about how common abortion is these days, because the stigma of having an illegitimate child is much less, and there is at least some kind of substantial financial support in these circumstances. And if you look at different regulations, laws, supportive arrangements that the state is undertaking for the vast number of illegitimate children out there, and I think it's an incredible number, particularly for some ethnic groups, but just in general, it might be approaching 50% of all the children born in the U.S. are illegitimate. And so some of the stigma to having an illegitimate child maybe have diminished, and thus maybe abortions are less frequent. I don't know
it's hard to find the statistics, and especially since RU 486, I don't even know if it's still called that. It's a much lower profile thing. I think well over 50% of abortions are
Right,
carried out that way.
Which still can have complications.
Yes.
However, you'd be an independent person's decision, and that would seemingly be possible unless something going through the mails, or some crime that you sent. If you lived in Connecticut and you sent some abortion,
procured abortion or
right,
something of that sort.
You sent the pills to. I don't know, Mississippi, or a really conservative state.
And that would be a place where Congress could certainly come in. But that raises a couple of interesting points right there. If you, to go back to Alito's opinion for a minute, and he emphasizes very, very strongly, and also, as far as I can tell, very correctly, and I must say, I'm a very small footnote to history here. He said that he had searched all the statute books, he'd searched all the opinions, using the editorial we, of course,
yes.
or the imperial we. He said he'd searched all the treatises, and the first hint from anyone in the legal community that abortion might be a constitutional right came out in 1968, and it was in an article published in my very own North Carolina Law Review, where I served as a Law Review editor many years after that fact.
Yes.
I think one good comeback to that, as you point out, times are there changing, that a good response is all of these laws were, to use the feminist word, were patriarchal. There was very little female involvement in the common law, in legislation, in the legal system, in the judicial system, for the vast majority of this history that Alito was looking at. And so they're going to respond, we're not bound by that. That was law written by men for men in a patriarchal society, and it should not be binding. So, or if not binding, it should not have the force that the courts give.
That's an interesting way to look at things. And I mean, maybe that's what's out there, that you're not, history, all the prerequisites of history, all the bright lines in history are all wrong because my ethnic group was not represented or whatever. And indeed, the whole notions of anything, property, rights, privileges, whatever the deal is, if rich people put the property protection laws in place, well, are you bound by that if you're a poor person? Did the people that put robbery, punishment in there, were many people very, very hungry that were doing that? And indeed, it looks like all that, with that type of logic, all sorts of, societal arrangements are under some assault. I think particularly punishment for people for minor property crimes. So they were just abolishing, we're not going to protect property the way that the rich people want to protect it. That's we need, and property should be very loosely protected, and a whole list of things, accepting that argument that you're not being bound. And then finally, you could make this case. If the people are, I think Thomas Jefferson talked about controlling the world from the grave. So if the voters are doing whatever they're doing,
the world belongs in usufruct to the living.
Yes, that's right.
We have usufructs in Georgia here, by the way. Rental properties are usufructs.
Oh, really?
Yes, they are not. They are actually not property interests. So
okay.
I'm sorry.
No, that's good. I mean, you want to expound on that?
It's simply what you said, that it's a present thing. It dies. It doesn't last throughout generations.
Right.
And I didn't mean to digress. We are starting to wind down.
Yes.
But I want to throw, if I could have a last.
You may, please.
Just a very cynical thought here.
Yes.
That Roe versus Wade produced the moral majority, which produced Ronald Reagan and the neocons who have been promising now for about 40 years, overturn Roe versus Wade, overturn Roe versus Wade. And yet they've never quite managed to do it.
Yes.
Roe versus Wade and pro-choice law managed to survive because Republican presidents never put in, until the last few years, a solid group of people who are opposed to Roe on the Supreme Court. And now you are hearing these screams for, we need for Congress to codify Roe, to pass the Freedom to Choose Act or the Freedom of Choice Act. I'm not sure, and it would be for another day, as to whether or not that law would in fact be constitutional. But for the sake of argument, assuming it is, in 2010, when the Democrats had a Democratic president and a veto-proof majority in Congress, and there was already a huge furor about abortion and had been for years, did they enact a Freedom of Choice Act? No, they did not. For the same reason, I would argue that Republican presidents would not put in a solidly pro-life court, because if you do this, a major talking point and a major issue to get your base going would have gone away.
Well, that's a rather sinister interpretation of
I'd call
a
it
politician,
cynical,
but maybe a reasonable one, maybe an
Yes.
appropriate one. Well, thank you so much for being
Thank
here,
you, sir.
Buck.
All right,
We'll take care. Take care.
Great.
Thank you for being here.
Thank you.
Thank you.
This program is brought to you by the Georgia Neurosurgical Institute. For over 50 years, rendering neurosurgical care to patients of all social conditions, treating complicated problems involving the brain, spine, spinal cord, and peripheral nerves, endeavoring to encourage quality care, medical research, innovation, and education on a local, national, and international basis.